Hello, and welcome to this Brennan Center Live event. Today, we're going to be talking about the latest twists in the United States Supreme Court's ongoing project called originalism and the court's continued use or misuse of history to justify some of its radical rulings that have essentially remade American law. We're going to focus today on some of the court's biggest cases from the last term, looking exactly at how the courts have used and deployed originalism and have distorted existing legal history theory. And we're also not just going to be looking backward, we're going to be looking forward, focusing on the way in which last term's developments give us a clue about what's going to happen in this term. We're in the month of October, after all, so we'll see what's coming up next. My name is Kareem Creighton. I'm the Vice President for the Brennan Center in Washington, D.C., and I want to tell you a bit about the Brennan Center before we get started. We are the Brennan Center, a nonpartisan law and policy institute. It works to repair, revitalize, and to defend our systems of democracy and justice so that they work for everybody who happens to live in this country called America. We're proud today, of course, to partner for this event with the Organization of American Historians, the largest professional society dedicated to United States history and its study. Thank you to OAH for their partnership on this programming. Now, the Brennan Center, of course, cannot support or oppose any candidate for office. We can, and today, of course, we will offer you a vigorous debate on the policies and positions that matter in our democracy. That's how we've always done business, and that's how we will learn and grow going forward. Of course, because we do it, we have to do it in a civil manner. We all know that, right? If you post, of course, rude or extreme language on our message board, you're going to be removed from the conversation, so just don't do it. That, of course, is one of the things we want people to be involved with so that we can hear all sides of these issues. We ask you also, of course, to follow this conversation on social media with the hashtag Brennan Center Live, one word, and, of course, use this live closed captioning if you need it. Now, today, to the business at hand, we're going to be talking with a group of all-star historians to help us understand a little bit more about the Supreme Court's project of originalism. They are some of the best in the business. They have focused, among other things, along with our members of the Brennan Center, on an organization that we put together called the Historians Council on the Constitution. It's an initiative that we organized in order to bring some of the expertise of the leading historians in our country to help us understand more about the court's ongoing project of originalism in the latest era. So it's my pleasure to introduce our panel today. They include Jonathan Ganap, Associate Professor of Law and Associate Professor of History at Stanford University, Gautam Rao, Associate Professor of History at American University, and Rachel Sheldon, Associate Professor of History and the Director of the George and Ann Richards Civil War Era Center. And joining them today is our own Tom Wolfe, who is the Director of Democracy Initiatives at the Brennan Center and is the founder of the Historians Council on the Constitution. So welcome all of you, and I'm so delighted to be able to have this conversation with you today. So let's start with, if we can, in the order I've introduced you, Jonathan. You're the author of a recently published book called Against Constitutional Originalism, a historical critique, which is, of course, a landmark takedown of originalism from a historian's perspective. So we thought there would be no better person, given your topic, to help us understand the foundations of today's talk than to start with you. So let's sort of ask the obvious question, Jonathan. What exactly is originalism for those who are new to the game? What's wrong with it?
Yeah, thank you so much for having me. So originalism is a theory. Originalism is a theory of constitutional interpretation, which says that we should interpret the Constitution today in accordance with its original meaning. So what the Constitution means today is what it meant originally at the beginning, and that meaning ought to decide constitutional outcomes today. And that original meaning should be treated as fixed unless or until lawfully changed. So it is set against accounts of how we should interpret the Constitution that sees the Constitution's meaning as evolving or changing as society's needs and values change as well. So originalism says Go back to the beginning, find the original meaning, and focus on that. The thought is that this will help ensure that constitutional interpretation is governed by neutral principles, that constitutional decision makers, especially judges, will have to look to something outside of themselves, and it will make it more objective. But the key is that originalism places enormous emphasis on history. I mean, no theory has placed more emphasis on history than originalism. History has always mattered to American constitutional interpretation from the very beginning, but no theory has made it the single thing that should predominate in decision-making. So if we think of lots of different criteria that could inform constitutional interpretation, you look to the text, you look to the history, you look to the structure, you look to past precedent, past practices, public opinion, consequences, where other interpreters weigh these more or less equally and try to draw from all of them. Originalism elevates history or text in history above the others and basically turns them into an authoritative trump card. So originalism places more emphasis on history than any other theory, and it effectively turns constitutional interpretation in the United States into an exercise in historical recovery. You want to know what the Constitution means today, you have to return to the past, often the very distant past, the 18th century past, when the United States Constitution was written and ratified, and figure out what it meant then. But the problem, as I see it, is that originalism too often fails to take seriously the very history to which it is staked, the very history that it claims is so important. And in particular, it fails to appreciate the significant differences between past and present. Above all, the differences between how we tend to think about constitutionalism and law today, how we understand the Constitution as an object in the world, and how people back at the beginning, at the founding, tended to think about those things. Originalism is usually focused on a narrow set of legal questions, focused on particular constitutional phrases or provisions. What did free speech mean? What did the right to keep and bear arms mean? What did little snippets of language mean? It often doesn't take a step back and ask the thing holding the meaning, the Constitution itself. Did people think about the Constitution? Did they think about constitutionalism as we tend to today over 200 years ago? Originalism often takes for granted a way of thinking about the Constitution and constitutionalism and law, assuming that those things also existed in the 18th century. So that to me is a really central problem with originalism. And we can see this in an example by thinking about one of the most important originalist cases in recent years, the case of District of Columbia v. Heller, which established a landmark case on the Second Amendment, established an individual right to own guns was protected under the Second Amendment. And what was striking to me, I think what's so striking here is that the case mostly focused on what the words of the Second Amendment meant without ever taking a step back and asking, is the way that we're thinking about constitutionalism and constitutional rights, was this shared by the people who wrote the Second Amendment? And you can see in the court's Second Amendment jurisprudence, beginning in the landmark Heller decision, a series of deeply ingrained premises that are actually quite anachronistic. They are not historically rooted. In particular, a notion of where rights come from, where our constitutional rights come from, what purpose they serve in the constitutional order, and who has the authority to define them. So 3 foundational principles that are all ahistorical. The justices who wrote the Heller decision, the lead author on that opinion was Justice Antonin Scalia, the longtime defender of originalism on the Supreme Court, assume that constitutional rights were created by enumerating them in text. You have a constitutional right because it's expressly laid out in the constitutional text. 2, the purpose of these rights was to constrain government. They were counter-majoritarian limits on what government could do. And 3rd, it was the job of judges to define their content. But if you go back to the founding, none of these premises were operative. People didn't think fundamental rights were primarily enumerated in text. They preceded what was written into the text. 2, they were not limits on majoritarian government. They were instead guides to legitimate majoritarian government. And 3, they did not think that it was primarily or exclusively the right of judges to be sorting out their content. So here we see a mismatch that I think is what I'm getting at between a way of thinking about constitutionalism in the 18th century and now that is very different, that originalists on the court usually fail to appreciate.
Thanks for that, Jonathan. And I'm so glad you highlighted the other question that I'm sure everybody was wondering: what are the justices who are most commonly associated with originalism? And you've mentioned, of course, the departed, dearly or not, Antonin Scalia. I want to turn to that case, though, Heller, that you mentioned, and ask Tom to kind of carry us through a little bit more to the present. Obviously, that was a very radical change to most of the law. I think most of us who went to law school thought about with respect to the Second Amendment, but the court didn't stop there. Can you talk to us a little bit about the world that happened basically after Heller was issued? What happened next in that process with originalism?
Happy to join in and happy to follow on Jonathan. So one key thing to keep hold of from what Jonathan just said is when the court in Heller said that the Second Amendment granted individuals the right to hold guns for their own self-defense, they were creating a historical fiction that ended up being damaging, but in sort of a time-delayed kind of way. So let's fast forward from 2008 to 2020. The originalists got a supermajority on the Supreme Court when then President Trump appointed Amy Coney Barrett to the bench. Once the originalists got their 6 votes, they really started pushing their advantage. So in 2022, in the Bruen opinion, the court ruled that gun laws that aren't supported by history and tradition of gun regulation in this country are unconstitutional. This was a very rigid historical test that did something that Heller hadn't yet accomplished, which was to undermine most gun laws in this country. After Bruen was issued, laws around the country fell, all on the same grounds, that there wasn't a deep historical precedent for them. Now, there was still room under Heller for courts to consider public policy, the greater good, a lot of these other factors that Jonathan mentioned. Bruen eliminated that room. The court instantaneously had to deal with the fallout from this past term in their Rahimi case. The court there was asked to consider whether it was constitutional for the federal government to stop people who are under restraining orders for domestic violence from holding guns. Now, of course, the answer to that question has to be yes. The Constitution has to bar that. Let me correct that. The Constitution has to allow the government to bar that kind of activity. So what the court did was basically loosen the Bruen test, all while claiming to be clarifying it. If you look at some of the top lines in this case, you might be tempted to think, Rahimi, not a bad decision. First, after decades of ignoring what academic historians were telling the court about historical truths, the court finally took up historical briefing by academic historians who had identified laws at the founding that showed that people who were viewed to be dangerous could have their guns taken away from them. The court also upheld the federal gun ban, so that gun ban still stands. And a war of sorts seems like it erupted amongst the originalists on the court, where they started arguing about the right way to do originalism. There are quite a few originalist voices joining with the liberal justices to say, maybe we shouldn't just be stacking up old laws and seeing if they're twins. Maybe we should actually look at the principles that are underlying those older laws. So, that was a trend we saw in some of the other cases this past term, particularly in the case about the CFPB's funding scheme. And all that fighting makes originalism look fluid and subjective and error-prone, exactly the kinds of things, as Jonathan was highlighting, originalism is supposed to eliminate. So it might be good, but let's keep a couple more things in mind. First, this whole opinion is grounded in the false historical assumption that the Second Amendment guarantees an individual right to hold guns for self-defense. It can be really hard to recognize or remember that that's a historical fiction because it's so deeply ingrained in our culture today and the way we talk about guns, but it's a complete fiction. Rahimi also made abundantly clear that the court's going to keep applying originalism both in these kinds of cases and in others. And I'd say the third thing to keep in mind is that the court's going to keep weighing in on guns. As I mentioned, post-Bruen, a lot of gun laws fell. In many senses, Rahimi was just like the first case that got to the court the fastest. But there were a bunch of other cases sitting on the court's threshold that the court sent back down to be reconsidered in light of Rahimi. And all those cases are coming back, and they're coming back with other cases that were working their way a little bit more slowly through the system. So, we're going to see more of the Supreme Court jumping in on guns, maybe as early as this coming term. And among the things that, we're keeping our eyes on are attacks on the federal law that prevents felons from owning guns, assault weapons bans, bans on guns in sensitive places, bans on large magazines for ammo. So this story hasn't ended by any means.
Thanks for that, Tom. And really present in both your comments and those of Jonathan's is this sort of sense of a difference between maybe how originalism was sold as a theory and how it's actually played out so far as a practice. In fact, one might say it's at least as relevant to politics as it is to history. At least those of us who are pretty critical of it would suggest that the court really is using this as a tool to manipulate a decision to get basically the ends that it wants in society. Now, that's a fairly perhaps critical view. I wonder, Rachel, let's turn to you, if you tend to agree with that. Is the court actually using originalism just to get the outcomes that it wants? Is there some method here to the madness? And is it perhaps that they just don't know enough history? What do you think is going on here, Rachel?
Well, I think the key is to recognize that originalism and history are not the same thing. So both Jonathan and Tom are sort of hitting on this in their comments, right? History as an academic endeavor is a particular way of investigating the past that requires real immersion in the sources, really trying to get a sense of what things mean in the time in which they exist. And that's not really the practice of originalism. And if you look at the opinions from this past term, you can see some of the ways that the justices talk about it. So in the Rahimi case, for example, in Justice Kavanaugh's concurrence, he says that the text says what it means and means what it says. And that's sort of a good indication of what we're talking about here, which is that it is not actually very easy to tell what the text means just from reading it. If you are a historian, you really have to immerse yourself in the documents and in the language of the time in order to understand what words meant to the people who were saying them at the time, because there is a separate language that exists among people who live at different times in the United States. It's not so easy to just imagine that people had the same kind of world that we have today. So what historians do when they try to understand the past is really think about people's lives in a holistic sense. We all have our own sort of cultural world that we operate in, and you can't isolate a word or an activity from that broader world. So the historical practice is very different from the practice of originalism. And no matter the differences in the ways that the justices might approach originalism, they are still engaging in a different kind of practice from history. And I think Jonathan's book really does a good job of explaining why they are engaged in a different kind of endeavor. Now, historians can get to some appreciation of what was happening in the past. It's not as though we're saying you cannot understand the past, but it does require an enormous amount of work to really immerse yourself in that world. And that world was very different from the world that we live in. And so you are making a kind of value judgment about what we should do today based on a past that was very different from what we are encountering now. So there is an ideological argument that these justices are making by saying we are going to both not use really the practice of history, but an originalist view of history, and to apply a version of that history that is not grounded in how people really understood their world to the present. So it isn't this sort of unbiased view of the Constitution that these justices are pretending to engage in. It's much more ideological and political than they pretend it to be.
Thanks for that, Rachel. I want to turn now to an area that has definitely been a long time coming from the originalist perspective and certainly promises to have a long-term impact for those of us who sit in Washington, D.C. And so, Gautam, I'm going to turn to you to talk a little bit about this case that everybody in administrative law loves, Chevron, where the federal courts have sort of adopted an approach that of understanding statutes that really focus on the interpretations that agencies offer and apply those interpretations, applies deference to those interpretations to resolve hard legal questions. Of course, what we saw recently in this case called Loper Bright, we saw the court say essentially, well, that's over. We don't defer to agencies as we used to, and essentially instead leave to federal courts the primary task of applying its own interpretive wits to understand how the law ought to operate. And along the way to get to that pretty radical decision, right? Chevron was on the books for easily 40 years. But the court this last term says, we don't want to do that anymore. And we think it's not necessary because of our originalist principle that leads us to the view that the founders really focused on separation of powers. And we see Chevron as offending that principle. Can you talk to us a little bit about what might be wrong with that theory and maybe what historians are catching that maybe the Supreme Court missed in that case?
Sure. And thank you, Kareem, and everyone. This has been a great discussion so far, and I look forward to being part of it here. So these two cases, the Relentless and Loper Bright cases, are all about asking the Supreme Court to overturn the longstanding Chevron doctrine, which basically boils down to the idea that judges were going to defer to government experts, administrators, when they were facing cases that they had to interpret, usually complex laws passed by Congress. So first, it's worth noting that these cases were kind of the sharp end of a long ideological movement that has a real problem with government agencies. And at its base, these critics really see administrative agencies as unjustly usurping individual liberty. And so for quite a while, going back to really the New Deal era, but really, I mean, we can see it gaining steam in the 1970s, 1980s. These ideologues have been trying to find a way to limit what government agencies can do in terms of decision-making abilities. So the corporations that brought these two cases use originalism to try to say that the founders had a kind of fixed understanding of what each branch of government was supposed to do. Congress passes the laws, the judiciary interprets the laws, the executive executes the laws. So they claim that the founders would never have approved of federal agencies making decisions. But in these cases, like in kind of so many originalist arguments previewed that we've seen here by Jonathan and Rachel in their discussion as well, these originalists in these cases offer an elegant and simple argument. But the problem is that the actual history of the founding era was quite different and really undercuts their case. So going back to 1789, there was a long-standing practice, really, of federal courts deferring to government agencies' interpretations of the law. In the 18th and early 19th centuries, and these are the times closest to the era of the founding, of course, federal judges were very reluctant to get involved in the kind of complexities of government agencies. They were much more willing to trust experts like a Secretary of the Treasury, Alexander Hamilton. In the founding era, federal officers like customs officials, a group that I've studied a great deal, and tax collectors had a wide range of discretion to determine how they were going to do their jobs. So this meant that in the founding era, federal agencies were interpreting the law. It wasn't only the courts that could do this. And so if we put it all together, history teaches us that the originalist argument in Relentless and Loper Bright were kind of simply put incorrect. As for the dangers that loom now from this case, they are really that the decisions can hobble federal agencies' ability to do their jobs by stopping them from managing complicated issues, often scientific and economic issues like clean air, clean water, fairness in the marketplace, in the labor market, and even things like nuclear power. The damage the court could do if it wanted to interfere is dire. And I think the question moving forward is whether it wants to interfere. And there may be a little bit of hope here because just recently, Justice Kavanaugh said that we shouldn't read too much into these decisions and that the court's conservative majority was really trying to accomplish what he called a, quote, course correction, end quote, instead of getting rid of Chevron altogether. But I think only time will really tell.
So I want to explore another piece of that decision, Loper Bright, Rachel, and I hope you can help me with it. And it's focused, right, as much as Jonathan had such great things to say about the sort of involvement of the courts with agencies, or maybe it's sort of lack of attention and deference to agencies. There's a question to be had about the court itself, right? A fundamental question as to whether the court, it seems as it wants to suggest in Loper Bright, that it is the arbiter of what is the final word on law, whether law comes from an agency, Congress, or perhaps even the President of the United States. Is that consistent with your understanding, based on your experience thinking through historical records, about how the founders thought about the court's role?
Yeah, it's a great question because there's sort of a telling part of the Chief Justice's majority opinion in Loper Bright pretty early on, where he cites Federalist 78, which is a Hamilton Federalist paper. And he says the framers envisioned that the final interpretation of the laws would be the proper and peculiar province of the courts. And it's telling to me because the chief added the word final there. The word doesn't appear in Federalist 78. And much of that Federalist paper is about the limited authority of the court, that it's the weakest of the three departments of power. And that's exactly how most Americans understood the Supreme Court for at least the first 100 years of our nation's history, and maybe quite a bit longer. We have grown accustomed to thinking of the Supreme Court as the final arbiter of the Constitution, but most Americans really didn't see it that way. For the first 100 years, there was a lot of resistance to the idea that the Supreme Court had that kind of judicial supremacy, that sort of final authority on the Constitution. And many Americans resisted it for very good reasons. Now, today, we don't really subscribe to the idea that people can just nullify what the court says, but we have given the court that authority over time. That's not something that was baked in from the beginning. So the power that the court has wielded today and over the past, say, 50 years is really new. It's not something that was accepted at the time of the founding, which makes a lot of the decisions this past term quite ironic, because the court is exercising this enormous power that it never had at the time of the founding, while drawing on the founding as its source of authority. And it's something that happens pretty frequently in their decisions when they make reference to the court as being this real source of expounding on the law. You know, a lot of references to Chief Justice John Marshall as saying that it is the province of the court to say what the law is, and to say what the Constitution means. And this is really sort of exaggerating the role that the court played at the time of the founding. It also misunderstands some of the way that the court operated in the 19th century. The court was much more tied to the people in the 19th century, from the founding through the 19th century, when Supreme Court justices rode circuit, when they served as circuit judges in addition to being Supreme Court justices. So they spent a lot more time with the people than our justices do today. We talk a lot about judicial independence, but the meaning of judicial independence was quite different at the time of the founding. And I think the justices could learn a little bit about the role of the judiciary if they actually knew some of this history.
So that takes us to a behemoth of a decision that we all were waiting until well to the end of the term to understand the court's take on, and that is, of course, the case Trump versus United States, which granted presidents, maybe just one president, sweeping new immunities from criminal prosecution. The originalism twist here is that the court takes the assumption that the founders needed a an executive branch occupant who had the ability, the quote was, to be an energetic executive, unbound by the law. Jonathan, let's take it back to you. Does that sound consistent with what you think about the founders and how they've understood the executive? It just sounds a little peculiar, but you're the expert. What do you think?
There's a short answer and a long answer here. The short answer is no to your question. It is not consistent with what they saw. The longer answer is, it's very nicely how you set up those two components, because they are very much tightly linked in the opinion. The idea of an energetic executive and one that's unbound by law or has broad immunity or presumptive immunity. And these things were not tethered in people's mind at the time. So first off, on the first half of that equation, do we want an energetic executive? Lots and lots of Americans at the time did not. They were very wary of executive power. They thought it smacked of monarchy. To construct a powerful unitary executive was to construct an office that resembled a king. So lots and lots of people at the time the Constitution was written and when it was presented to the public for ratification were very concerned about that prospect. So there was not broad support across the board for an energetic executive. Now, lots of people who constructed the presidency, lots of important framers in Philadelphia, very much coveted an energetic executive. They thought what had been lacking in American governance up to that point, what had made the first national government under the nation's first constitution, the Articles of Confederation, so inadequate, was in part that the executive branch of the national government lacked necessary energy. So lots of those people tried to construct a more energetic executive. But like the people who were wary of executive power, they in no way, shape, or form thought that this office would be unbounded by law. Quite the opposite. They emphasized time and time again that the great advantage of creating a unitary executive that had great energy is that this would come with accountability. People would very clearly know who was making the decisions, who was responsible for them. It would create a sort of feedback loop that would maximize accountability rather than minimizing it. And in addition to that, one of the basic premises that guided people at the founding was the idea that they were constructing a republic rather than a monarchy. So the person who would preside, this chief executive officer, a national Republican executive, would not be a monarch in this key respect. This person might have great energy and power, but they would not have the traditional privileges and immunities that one tended to find in monarchs, including the British king. And they emphasized this time and time again, especially when they presented the proposed Constitution to the American public for consideration in the ratification debates. A lot of people who were wary of executive power said, will this president be accountable? And key framers said multiple times, of course, there are two primary mechanisms by which a president who violates the public trust can be held to account. First, there's the impeachment mechanism, which is a political remedy for political crimes. And then there's this entirely separate track. The courts of justice are open to prosecute a president once he or she has been removed from office. So they emphasize time and time again that part of the reason you could trust giving more power to this individual that would be called the president was precisely because they would be liable, criminally liable, if they broke the law. And they continued to say that not just during ratification, but thereafter. In fact, they emphasized, there's a really revealing quote from Charles Pinckney, who had been a framer at the Constitutional Convention about a decade after, emphasizing that the delegates to the Constitutional Convention had made an explicit choice. They gave certain privileges, I mean, they're written right into the Constitution, to members of Congress, immunizing them from things they say on the floor of Congress from certain kinds of prosecutions. And they said, we did not extend any such privileges, any sort of cluster of immunities to the President of the United States. So you have this pretty significant historical record making it very plain that the people who designed the Constitution and defended it and tried to put it into operation thought one of its key organizing principles, what would make it a republic rather than a monarchy, is that the President of the United States would be accountable in a very real sense, not just politically, but also criminally if need be. And that would very much be on the table. And anything to the contrary just simply misunderstood what the United States of America was, and would take it to be a monarchy rather than a republic.
I want to go to your book again, Jonathan, because I said earlier, you were kind of throwing haymakers in the book at originalism, not just on sort of ways in which they sort of came out the wrong way on a case, the court adopting originalism as a sort of approach, but you really question, I think, the method of originalism with the assumption that you attack, which says that, the founders viewed the Constitution in the same way that the originalists say they're understanding the Constitution, that there's symmetry between the two. You're suggesting that's not quite the case. I want you to walk us through, if you can, sort of how you get there. What's the argument that really isn't quite accurate?
Yeah, great. So there are different, as I mentioned in my first answer, there are different ways to think about how we relate the past to the present. But the first key question to ask that I think is not often asked among originalists is the way that we tend to think about constitutionalism now, the organizing premises and assumptions that guide modern constitutional law, that define for us what the Constitution is, how it acquires and communicates its content so we know something is in the Constitution as opposed to outside of it, who has the power to enforce and interpret the Constitution, what it means to say that its meaning is fixed. All of these big foundational assumptions that define how we think about constitutionalism and constitutional law, were they shared by people in the 18th century? And my basic argument is they were not, or there was deep disagreement over them. And if we're interested in recovering the original meaning, that is the meaning that the Constitution communicated to people in the 18th century, we have to bring that very different way of thinking of constitutionalism back into focus, because what the Constitution said in the 18th century was entirely a function of how the Constitution spoke, how it communicated information to people. And how it communicated information to people was entirely a function of how people understood constitutions to work. So I think a good example of this that helps sharpen up the differences and some of the key ways in which originalists often take for granted certain things about the past, impose modern ways of thinking about constitutionalism on the past, is how written constitutionalism worked. So the United States famously has a written constitution. You can carry the US Constitution around in pocket form. You can go see the parchment copy in the National Archives. And what originalists often assume is that because it's written, its content therefore is entirely tethered to the text. Now, the Constitution can imply a lot more than the bare words of the text say, but ultimately it's a textual instrument that communicates its content through its text. I mean, the written Constitution tells us what is in the Constitution, what is outside of it. But in the 18th century, people thought very differently about constitutions because they thought very differently about law. They didn't think that law was simply something that human beings made or posited, something that they wrote down and expressly assigned. It was also something that was out there, like the principles of mathematics awaiting discovery. And the sources of law that were out there, that a sort of well-versed legal theorist or a careful interpreter would get in touch with, sort of fundamental principles of justice that could be known through reason, or things that had been established through custom over long periods of time, that there was a harmony between all of that fundamental law that already existed and what the written Constitution specified. So to understand what the Constitution did in the 18th century, to understand what it said, you had to recognize how these two things fit together, what was written and what was unwritten, and you had to harmonize them. And that's what people did in the 18th century. So if you instead say the only constitutional content that we have in the Constitution is what is written into it, you were in effect deleting a lot of the content that people took for granted in the 18th century to be part of the Constitution. And as a result, you were in effect creating a new kind of constitution that didn't exist in the 18th century. So if you look at the 18th century through the eyes of modern constitutional law, merely assuming that what we take for granted was operative back then, you're not actually going to be talking about the original Constitution. You're instead going to be talking about an original Constitution that is really a modern legal fiction. And in so doing, you fundamentally misunderstand, I think, picking up on what Rachel said about what is necessary to recover things in the past, what one must do if they're interested in figuring out what the Constitution actually said at the time it was written.
So I want to hasten on to Tom. We're running right to the point where we're getting to questions and answers from our audience. But Tom, I wonder if you can tell us your thoughts about whether all of this conversation today is an indication that, originalism has run its course. Are we at the point where we're seeing all the fissures in originalism and we're just waiting for the final knockout blow? Jonathan's book may be it, but what do you see as this sort of point in evolution about the story of originalism on the court?
Yeah, I would say originalism is still on the march, even if the originalists can't agree on what the marching orders are or where exactly they're going. Some of the places we might see originalism pop up over the course of this term or the next. The first, I would say, is the next phase in the prosecution of Donald Trump in DC for trying to overthrow the election. There will likely be questions raised about the historical roles of presidents and vice presidents in the electoral process. We dug into this a little bit in the historian's brief that Jonathan Gautham and several of others filed earlier this term, but that'll probably pop up again. Challenges to the constitutionality of leadership structures for government agencies, particularly multi-member agencies, constitutional challenges to campaign finance laws as being kind of insufficiently originalist. All these things may be coming. One thing I think to keep in mind, though, is that even if the Supreme Court never issued another originalist opinion, we could spend the rest of our lives digging out from the aftermath. Right-wing actors are using the opinions that the court has issued to upend our law all over the country. We are now living and suffering in a world that originalism has created. I spoke about the ongoing flood of Second Amendment cases challenging gun laws. Originalism is the reason why that's happening. You've seen the flood of reports of horrific gun violence. Originalism is letting that happen. In the 2 years since the Dobbs opinion overturned Roe v. Wade, reproductive rights have been under assault all around the country. Dobbs threw the issue back to the states, and that's resulted in waves of new litigation. Most of this has unfolded in state courts, and most of it has involved protections for abortion. If you'd like to learn more about how those are playing out, I could recommend the writing of legal historian Mary Ziegler, who's now doing periodic updates on that litigation for the Brennan Center State Court Report. We've also seen sweeping attacks on civil rights laws and social justice initiatives under the banner of the so-called colorblind constitution or the race-neutral constitution that this Supreme Court has unleashed in the world. When you hear news about litigants sending warning letters to universities about the composition of their newly admitted freshman classes, like we saw last week, that's all powered by the fiction of the race-neutral Constitution. My colleague Chihiro here at the Brennan Center has written about how these challenges are playing out. Historians Council members Kate Mazur and Greg Downs have also written a lot of historical scholarship on this issue that they published earlier this summer. Historians and others have been rising to the occasion to respond to these problems, but the flood is difficult to stem, and I think that's the reason why we need to displace originalism. Kareem, if I could throw one question back to our panelists before we go to Q&A.
Sure.
We had another remnant idea floating around in that Trump v. United States opinion, which is this unitary executive theory concept. This is something that Gautham and I have talked about in the past, and I was curious if he could put a little more meat on the bones of the kind of historical issues with that kind of totem of conservative legal thought.
Sure. So this unitary executive theory, that Jonathan mentioned as well in his discussion, is basically the idea that a president is supposed to retain the powers that a monarch would have had back in the 18th century, and should have relatively unchecked authority over governance, and in our case, the federal government. So this is another legal theory, constitutional theory that became very popular in the late 20th century, and then in the first decade of this century. But again, the history of the founding era really does undercut the theory, and it takes a lot of stretching to get to a place where we can re-envision the presidency as a quasi-monarchy or an actual monarchy. So above all, it requires forgetting about the American Revolution, which, the central tenet of it was anti-monarchical. And in order to make this unitary executive theory work, you really have to cherry pick from the legal and constitutional debates around the Constitution to overlook what the presidency actually looked like in the founding era and frankly, for many years thereafter. And this leads us down a dangerous path, frankly, in terms of executive power now in the wake of the immunity decision. We have, for instance, a extraordinarily unworkable standard called presumptive immunity. That means it's going to be a really long time before even if president does manage to get their activity scrutinized before a court, it will be a really long time before anything close to justice would ever be done, if it would be done. It also gives a president, any president, license to break the law if they just are using their so-called formal powers to do so. And by saying that President Trump's alleged directions to the Department of Justice are immune, it means that all sorts of presidential paperwork can no longer be used in these sorts of legal inquiries about presidential behavior that will obstruct accountability moving forward, not just for Trump, but for any president in theory. The theory in itself is problematic, and the history does not accord with it. And it's, as Tom was mentioning, it's left us with a real mess.
Well, let's move, if we can, to questions from our audience. And you all have been quite good in the audience of giving us some options. I want to start with a question for Rachel, which actually combines two questions. The first: can you discuss other ways in which the court fails to recognize the differences between our legal culture today and the founding era? And second, a provocative question relevant to some of the work that the Brennan Center is doing. Do you think the founders would have supported current proposals to set term limits on the United States Supreme Court justices? Let's start with you, Rachel. What are your thoughts on both?
Yeah, so I think this is a perfect example of the kinds of problems of thinking about history when we're thinking about the court. So the question about term limits is sort of an awkward question because the founders didn't talk that much about term limits, and folks who were interested in reforming the court didn't talk very much about term limits because the culture of the court was not one where term limits made a lot of sense. Not because term limits wouldn't be necessarily a good solution to current reform problems with the court today, but because they didn't serve as a good solution to problems with the court in the 19th century and in the late 18th century. There were lots of efforts to rein in the power of even a weak court in the late 18th and 19th centuries. And there were dozens and dozens and dozens of proposals to do so. And most of them were not about term limits because term limits wouldn't have solved those problems. Some because of the fact that justices tended to die a little bit earlier because, you know, people died earlier in the 18th and 19th century. And also because it wasn't that exciting to be on the Supreme Court in the 19th century because you didn't have as much power. So a lot of people left the court. It was not unusual for members of the court to leave. So thinking about the legal culture around the court, sort of what was the process of becoming a Supreme Court justice and what was the culture of being on the court? What were the incentives to stay? What might you actually do if you left? There were justices who went on to serve in other political positions or who were lawyers in front of the court once they left the court. That changes the perspective on why you might want to reform the court in other ways. And so there are many moments in the 19th century where the court expands. There are times when the court contracts. There are other efforts to move the court around. The court is in various rooms in the Capitol building. They shift which circuits the court goes to, members of the court go to. So reforming the court was something that members of Congress wanted to do, and members and folks living in the United States. But term limits weren't one, not because term limits were necessarily a problem, but because it wasn't a possible solution. So the question itself presumes a continuation of 19th century culture into the 20th and 21st century, but it's just not the way that people thought about the court. So that gives you a sense of how history really operates differently from our current moment when we think about legal culture.
I want to turn to another question that came from the audience, and it was, I believe, Jonathan earlier who name checked our first originalist, or at least the one in this conversation that was first. The question is, why do you think we saw disagreement among the court's originalists last term? Can we expect those divisions to grow? I'm reminded of Justice Kagan, who at one point said, we're all originalists now. I'm not sure if that's true, but Jonathan, can you talk a little bit about whether you are seeing the same divisions among originalists? Are all originalists the same?
So if Justice Kagan counts as an originalist, and she did offer that famous quote, then there's definitely disagreement among the originalists and will continue to be. But if we take the 6-justice majority, conservative majority, that is often referred to as the originalist majority, we definitely saw disagreement, especially in the United States v. Rahimi case that Tom mentioned earlier, that's fleshing out the scope of the rights under the Second Amendment. And I think there are a lot of different reasons for it. The primary one being that the rhetoric of originalism presents history in a very clean fashion. If only judges could stop focusing on what is superior policy or morality or what are good outcomes or how much the nation has or has not evolved or what public opinion wants, if instead they look at something more fact-based, more empirical, more outside of themselves like history, it will place them on a much surer path and they will be able to engage in a more neutral, objective approach. But what tends to happen, and all historians can relate to this, is when you venture into the past, you find a lot of messiness. You find a lot of conflicting principles, ideas, and arguments that you have to make sense of. And it provides a lot of the same avenues to pick and choose if you are so interested. So one example here is, what is the relationship to what came before the American Revolution and the writing of the Constitution and the Constitution itself? Americans grew up as subjects of British constitutionalism and British common law. They absorbed a lot of that. They established a lot of that in their colonies that then became independent states. What happens to all of this enormous body of law following the revolution? Is it immediately deleted because that was monarchical British law and American law needs to be different? Or is it part of Americans' inheritance and is sort of quietly downloaded into the Constitution in a certain respect? Justice Kavanaugh, in his concurrence in Rahimi, said, we should not make the mistake of assuming that British law as background principle is quietly downloaded into the Constitution. But yet, as Gautam was saying, the theory of the unitary executive, that the president actually has these massive far-reaching prerogatives that had previously been part of the royal prerogative of the British Crown, very much presupposes a kind of quiet download of that sort. But in addition to that, it's not just a matter of what the words of the Constitution mean. You also have to understand what the relationship are between key constitutional concepts. So in a lot of cases, which included Rahimi and so many of the Second Amendment cases, you have to have some understanding of what constitutional rights are, the scope of them, and what are the limits to how government can properly regulate them. And those things are not going to be obvious from just reading the text of a provision like the Second Amendment. You need a more robust understanding of how constitutional governance works. And it's not surprising that when you get into that space that can move you in many different directions, Justice Clarence Thomas and Justice Amy Coney Barrett and Justice Neil Gorsuch, despite having agreed on the Bruen decision 2 years prior, 2 years later can't agree on the original meaning of a document written 2 years before that they all wrote, and end up splitting on it in key ways.
So there's a bit of a wild card question I want to pose. I'm just going to make it a jump ball for anybody interested. There was a question that came across about what role, if any, does dark money play in the prevalence of originalism on this court? Anybody have any reaction to that? This may go to the politics of the membership. Tom, I'm going to direct it to you, since I suspect you've been thinking a little bit about it to start.
Yeah, some of this is a question of the kind of bigger apparatus that exists to promote originalism. Some of our colleagues on the council have talked a little bit about a kind of like originalism factory or an originalism Inc. There, I think, would be a tendency to think, okay, if the Supreme Court's talking about this, if legal academics are talking about this, these are kind of like, this is a mainly academic discourse, a theoretical discourse, a jurisprudential discourse, and that's what's driving all of this. But it's really the opposite. Originalism was mainstreamed into American ways of thinking in the 80s by conservative activists, some of them in the DOJ, some of them spread throughout the judiciary, others in the academy, to undo basically the Warren and Burger courts of the mid-century, to undo the civil rights revolution, to undo Reconstruction, and to put us back into the 1700s. That means that the political justification is leading the theory rather than the other way around. And then it gets loose and it kind of starts proliferating in this kind of meme-like way. But it's very much bound up in the story of how the conservative legal movement grew and metastasized and began to take over many institutions, particularly the federal judiciary. And so it is very much, in a sense, a sort of political story. And what we're seeing now is in originalism in the Supreme Court is a kind of rhetoric to justify a conservative policy view on the world and to justify a rolling back of our constitutional rights.
So I want to end today with a question for each of you, which goes really to, what you want the people who are listening today and thinking very carefully about all the great ideas that you all have offered. What do you want people to walk away with today after, being introduced to all of these different facets of originalism and its failings, or at least its shortcomings? I'd love to start with Rachel and get each one of you to give us your take on, in a very, short form, what is it you want people to walk away from this conversation understanding about originalism?
I think the main thing I would like people to take away from it is that the court has not always been this powerful. It's at its peak of power right now, and originalism is one tool that this court has used to build that power, and that we should be very wary of any kind of theory of the Constitution that allows the court to have this much power.
All right. To you, Gautam.
Well, first, I'd hope that they walk away with Jonathan's book, which truly is outstanding. And I think a lot of the things that we've discussed today, he gets into in detail that we couldn't. So I would strongly urge people to get a copy. I think to underscore Rachel's point, that the history that the Supreme Court's conservative majority is drawing upon is a great deal more complicated than the Supreme Court's conservative majority would have us think. And really that the only way that we can put this in front of the public and have what originalism is actually doing become clear is for the study of history to be put alongside it. And so I would just urge readers and listeners, to this and anyone else who might see it down the road, to when you see historians weighing in on these topics, to see what they have to say, because I think they can oftentimes offer a different perspective and a deeper dive on some of the history that gets glossed over in some of these opinions.
Thank you. And I know Tom will forgive me. I would like to give the last word to Jonathan, author of the book that we've all been talking about. What would you like people to walk away with today?
So originalism, for a long time, really since it came into existence, has claimed the moral high ground in constitutional interpretation, insisting that originalism is not just a good way or a better way to interpret the Constitution, but it is the only way that is faithful to the Constitution. All other theories try to turn the Constitution into something it's not. Originalism is the one theory that takes the Constitution as it is, that recovers it as it was written, and respects what it has always been. But if we appreciate the ways in which originalists tend to not appreciate the differences between past and present, and especially the difference that those differences make, we can see that originalism does not stick true to its claim that it is maintaining fidelity alone to the Constitution as it's always been, but is actually engaged in an exercise of wrenching an 18th century Constitution out of the 18th century into a modern world, imposing upon it a whole set of constitutional and jurisprudential assumptions that people in the 18th century did not share. And in the process, mold and shape it into something it was not originally, in very much along the same lines as those theories of constitutional interpretation it disparages. So I think it's really important to see the rhetoric of originalism and how that rhetoric presents a certain morality tale of how we should engage with the Constitution, and how a proper accounting of the history undercuts that.
Thank you, Jonathan, Gautam, Rachel, and of course our indefatigable Tom. Thank you so much for your wonderful insights. I want to thank everybody for joining us today at Brennan Center Live, and we look forward to seeing you on our next installment. Have a great afternoon, everyone.